much, Rachna, for joining on this podcast. It's really a pleasure to have you here.
Thank you, Simit, for having me here. I'm so happy and excited to share my knowledge about IP.
Yeah, absolutely. This was, long due, I suppose. I've been wanting to do this for quite some time, but I'm glad that I mean, we've had the chance to do it now
Yeah,
because IP is one issue which I feel that, is often kind of neglected, especially in the social sector. And I'm glad that we can, talk about it and, explore a bit in detail about the issues around it.
yeah, absolutely. I completely agree with you. Not many people take IP seriously, so let's go ahead with the issues that the not-for-profit face, and what are the benefits that they can get by, securing their IP rights.
Absolutely, absolutely. You've been working in this space for many decades now. What are the typical sort of common IP related issues that come up, like in general, and probably you could also talk about specifics in the social sector as well.
So, I mean, before I explain about the common issues that not-for-profits face in this area, I would like to a little bit explain about the significance of IP and what are actually the basics of different IP rights that can be protected and how they are structured under the law. Because I feel that there is lack of awareness. Most people only understand trademarks as the IP rights, but there are few more IP rights which are important. It is, significant to understand what are those. So, as I said, the most popular and commonly understood IP rights are the trademarks or the brand names. And not-for-profit organizations often rely on brand names, logos, and there are other distinguishing signs and symbols that represent them or identify them uh, and distinguish them from others. Nowadays, we also have non-conventional trademarks, which are like color marks, smell marks, and sound marks as well, which can be registered.
Hmm.
So these can be protected as trademarks under the Indian trademarks law. Trademarks actually help non-profits and other companies or individuals to distinguish themselves from others. And if they're not protected, they can be misused by third parties and cause consumer confusion and deception. So this impacts the credibility and reputation of the not-for-profit entity as the consumers are misled into believing that the proceeds are benefiting the not-for-profit that they trust, but whereas actually they are not. So it kind of shakes the trust of the donors.
Right.
Yeah. To give you an example of this not-for-profit organization, which I think everybody is aware of, called Missionaries of Charity,
Hmm.
which is a religious and charitable organization, they had to file three trademark applications for their logo. There was a blue and white striped sari to protect against misuse. And there
Right.
were reports that there were some unauthorized individuals which were using this logo to sell the mementos, books, and misleading the public into thinking that the proceeds were being directed to the missionaries of charity, whereas that was not true. So
Right.
this is an example of how IP or the trademarks can actually be misused. Then there are other examples of organizations which everybody is familiar with, like Oxfam, Greenpeace. They have registered their IP, their trademarks. There was another case with Worldwide Fund for Nature, WWF, a trademark infringement suit.
Hmm.
They had filed against World Wrestling Federation, which was
Right.
abbreviated as WWF, over the right to use the initials WWF. This also reminds me of an NGO that we were supporting at the time of the COVID-19. They were actually doing incredible work and they became so popular, we cannot name them.
Hmm.
But they had taken huge piece of land and they were supplying oxygen cylinders at that time to those who needed them, and they saved numerous lives at that time. So
Hmm.
due to the popularity, they started to get funds not only from the nation, across the nation, but also from overseas, as NRIs wanted to help their families who needed the oxygen cylinders.
Right.
So, as a result of the popularity, there were some third parties who started to use their name illegally. They set up bank accounts and projected as being a part of their organization. And they made, like, with an intention to make unlawful gains.
Hmm.
So overall, trademark protection is vital for non-profits as much as it is for the, for-profit businesses to safeguard their brand authenticity so that they can send a strong message that the trademark belongs to them and they are able to enforce their rights against unauthorized use, dilution, and reputational damage. So although India recognizes unregistered trademark rights as well, however, a registration does help. It does make things easier to enforce rights. In the absence of a registration, the burden of proof is on the brand owner to prove its ownership. Like, we have the physical properties where, if you're staying in an apartment for many years, but you haven't got it registered with the MCD,
Hmm.
and one fine day you have to prove the ownership, then you will have to prove that yes, you are the owner of that apartment. So
Right.
similarly for the intellectual property rights as well, it is not mandatory to register. India is a common law country, so it does recognize unregistered trademark rights as well. However, it does help to kind of prove your ownership in case there is a dispute, or or an infringement by a third party. Then we have copyrights. Copyright protects literary, artistic, dramatic, sound recording, and cinematographic films. For example, books, music. Then we have poems, scripts, movies, dance sequences, content in the current times, paintings, sculptures, etc. There are, like, some NGOs that we support who are into the education space, and they create content, they write books and materials. um, so they are quite particular to register every piece that they create. Although
Hmm.
again, copyright registration is not mandatory. India is a signatory to the Berne Convention, whereby copyright registration is not compulsory, and you can also enforce unregistered copyright. But again, as I said, for the trademarks, it helps to enforce your rights if you have a copyright registration. And then it again, depends on the strategy followed by each organization, whether it is a not-for-profit or for-profit,
Hmm.
whether, they would like to invest in the protection of their creative works, how it can be exploited. So maybe in the case of the NGO that I'm talking about, who registers every piece of creative or literary work, the content that they create or the books that they write, maybe because it is being, they have the risk of it being copied by third parties. They,
Hmm.
they are suspecting that, so that is why. So it is up to, it is the internal strategy of every organization. Then the third IP, which is also popular, but
Hmm.
maybe not so much for non-profits, only who are in the technical field, is patents.
Hmm.
So non-profits can also protect their inventions or technologies by filing patents, especially when they develop innovative solutions for social impact. So examples include healthcare, environmental technologies that can be licensed to promote global development.
Right.
And it helps, to register a patent, like, for example, non-profits in the global health sector, such as World Health Organization, WHO. They often work with organizations like the Medicines Patent Pool to enable licensing of life-saving drugs to low-income countries at affordable prices. So
Hmm.
it does help to protect the inventions well in time. A fourth type of IPR rights, which is not much talked about, is trade secrets. So there are
Hmm.
certain rights which are not covered under the conventional, IPRs, patents, trademarks, copyrights, designs. So they can be covered, especially in the current era where we live. There are new types of content and new types of creative works which are not covered under those headings. Then there are trade secrets, and there's a lack of awareness on what qualifies as a trade secret and how it can be protected in the absence of a dedicated statute. But then trade secrets are quite useful because they protect the valuable proprietary information that non-profits and for-profit organization can protect. to maintain a competitive edge, which includes, like, in the case of not-for-profit organizations, it includes operational processes, donor databases, proprietary strategies. So one example that I can give, because we worked with them, was a healthcare-focused not-for-profit that had developed a specialized method for distributing medical supplies to remote areas, temperature controlled for injections environment. So protecting this method as a trade secret could give the organization a competitive advantage by ensuring that others cannot replicate its efficient service delivery. Then there is this donor databases, which is also, sometimes there is a high attrition rate. They copy the
Hmm.
donor databases, they take over the crucial information. It happens with the for-profit organizations as well. It is a common problem.
Right.
Yeah, so those databases as well can be protected as a trade secret, provided certain protocols are followed to label it as a, business secret or a trade secret information or confidential information, and then only it can be protected. So those are, important. Then there are proprietary strategies, which I mentioned about, that, sometimes the organizations have unique strategies to
Hmm.
achieve their social missions. These could be in the areas of fundraising, marketing, community engagement, and those are unique to an organization, and they want to protect it. They only, organizations feel bad when those strategies are being copied. Although,
Right.
yeah, till such time they're not copied, they feel, oh, it's okay. If anyone else is also using them, it's fine. But when they are actually copied, then no one likes it. So I think it is important to protect trade secrets as well. And overall, like, I spoke about the different kind of IP rights that exist, and how not-for-profit organizations can, identify the and capture the IP that they're producing, and and decide that which category are they going for, that an IP consultant can advise. But these are the basic heads of IP rights, and there are, of course, numerous benefits.
Right. Wow. That was very elaborate, and there are so many issues that you talked about. I'll pick up like one of the things that you mentioned, which is very relevant to organizations in the social sector, which is about protecting their donor databases. So one is obviously the employees, within the organization who have access to that kind of data, but the other is also the service providers that they are working with, whether it is a website person or the mailing service providers, for example. So they are dealing with a lot of data, and there are times when organizations have to share that. And in my earlier roles, I have seen, these issues being brought up by organizations where, there is kind of lack of clarity in terms of how could that be protected. Can you like delve a little deeper into that issue as to how an organization can protect this?
The protection of databases is partly also covered under the copyright law. As I said, trade secrets we don't have a separate dedicated law for protection of trade secrets. So the only way to protect a trade secret or business secret and databases, donor databases or any database, like we have client databases in a law firm that we
Hmm.
need to protect. So the only way to protect them is the best way to protect them is through contracts and through creating awareness internally amongst the employees, amongst the contractors, that this is a confidential information, and and no one is authorized to copy it and use it to their advantage. Then there are agreements with the employees at the time of joining. It can be one of the clauses that
Mm.
the like we have an agreement, kind of a pop-up that comes when people log into the systems, that they will not copy any content or any databases, and and we have, like, a system where employees cannot um, you know send any information on their Gmail IDs.
Hmm.
So those kind of mechanisms are important to be in place. But the most important thing is to create awareness and, kind of send a message around that this is important to us and this is a subject matter of copyright. This is our, business secret or a trade secret, and any copying or any violation of this will, we will take action in case of any violation of that. Same goes with the contractors. An agreement has to be in place, which should be robust, and then creating awareness. So those are the two main areas.
Yeah, and also I think as you rightly mentioned, like at the start of the conversation, a lot of times, within the sector and even outside, I think there is this common tendency, wherein when something happens or when something is being infringed upon, only then you kind of realize that, this is an important issue and that it should have been protected. But by the time it is, too late,
Yeah,
uh, and there isn't either because of lack of awareness or you just don't feel that that is important at that time. You
yeah,
realize the importance of like IP issues only when something happens.
yeah.
So I want to ask as to what are the steps that organizations can take to make sure that first of all that their IP is not infringed upon, and if it is, what is it that they can actually do?
Yeah, so it can help, like, the not-for-profits need to have an IP policy in
Hmm.
place, which involves, first of all, creating awareness, as I mentioned earlier as well, internal kind of an awareness about, what IP exists in the system. Then consider their own activities, the not-for-profits activities, and the IP needs that they
Hmm.
have. So the type of IP protection varies, based on the non-for-profit, not for NPO's mission. For
Right.
example, an NPO focused on creating educational content will likely have a stronger need to protect copyright
Hmm.
for its materials, while there is another one that develops technology or software. That may need to address patent protection and software licensing. So that has to be aligned, the mission and vision of the NPOs with the IP requirements. Then identify and track the type of IP, which I explained that there are various heads, trademarks, copyright, patents, trade secrets. There is also geographical indication, designs, few other IP, lesser known IPs. So they need to identify and track the type of IP that the NPO is creating, then define ownership of IP. So
Hmm.
that has to be very, very clear. There are a number of issues around definition of ownership of IP, that who owns the IP, which is a common problem in NPOs as well as for-profit organizations. This especially for the IP which is created internally by the employees during the course of their employment
Hmm.
working hours. Then, in case of NPOs, there are volunteers who are creating IP.
Hmm.
There are third-party contractors or external collaborators as well. So, there needs to be a formal ownership and agreements that who owns the IP.
Hmm.
There are so many lawsuits, decided cases, landmark judgments on this point, where an organization had outsourced, for example, making of an advertisement to third party,
Hmm.
and there was no agreement in place. So the creator will claim that they have copyright on it, whereas you have paid for that work. So
Hmm.
ideally you should own the IP. But in the absence of an agreement, a formal agreement, the IP right will go to the one who creates it.
Right.
So there has to be, clarity in terms of who owns the IP, whether, again, from the employees as well, the organizations who do create IP on a day-to-day basis, they get agreements signed at the time of employment that any IP created during the course of their employment or during the working hours will belong to the employer.
Hmm.
So those agreements will necessarily, clarify about the ownership of the IP.
There are so many issues that have been covered like by you while talking, but I'll pick up like one of the things that you mentioned, which is about like in the earlier part you mentioned about Greenpeace and WWF and other larger organizations
Mhm.
as to how they have been proactive in making sure that their IP is protected.
Yeah.
So, are there any lessons that you think smaller nonprofits could take from them in terms of when it comes to protecting the IP? You also talked about, like, having a policy. Could you outline a little bit in terms of what does that policy need to sort of entail, or what does it typically entail?
NPO, although their ultimate aim is, they are, it's not for profit, but when they are preparing, crafting content, or making a poster, for example, or
Mm.
any digital, media content or creative work that they're creating, the purpose of it is also to raise funds.
Hmm.
So it is not exactly, a not-for-profit, non-commercial use of it. Non-commercial use would technically mean for educational purposes, like, if you're using it for a lecture or educating someone, then, like, if I make a presentation and use brand names and logos, or, articles from the public domain, which is, just to educate students, then it is okay to do that. That will constitute fair use. But if I'm using it for commercial purposes, then it does not amount to fair use.
Hmm. Very interesting, because I think this is something that I have seen as well, especially with organizations in the social sector, is that when they have to make any presentation, for example, or use it, in their pitch deck, I think there is a normal tendency to use like photos from Google Images directly,
Right. Yeah.
without checking, whether it falls under Creative Commons, for example, or whether it can be used. Uh, that brings me to the point about like Creative Commons as well. Could you share what exactly is Creative Commons, and whether like why should organizations use or probably go for like material or photographs, for example, which are under Creative Commons?
So, as I understand from your question, is that sometimes the source is not identified. So, what should we do?
Correct.
Scenarios.
Yes.
So, so if you ask me, I would say avoid using that if the source is not clear. Why get it? Take the risk.
Right. All right. Okay. But just, I mean, related to that, and you covered that, like, because a lot of times organizations, because they are registered as a not for profit, there is a belief, or a tendency that because we are a not for profit, it's okay to reuse someone else's content and share it on our social media, for example.
Yeah.
Uh, and I don't know, like, is there like a gray line, or is there like a uh, is it like a clear black and white in this case, or can there be exceptions?
Yeah.
Because yeah.
So yeah, so as I said, there are exceptions under the copyright law, but there are, at the same time, there are gray areas. Like in the current times, there are issues related to the AI, where, courts have actually appointed an amicus curiae to
Hmm.
find out what exactly constitutes fair use.
Hmm.
It's for the training that is given to the AI models, whether, so there is a dispute over that, if it's a copyrighted content that is being fed into the AI models,
Hmm.
does it constitute fair use? So there are gray areas such as, the one that I discussed, and it is for the courts to interpret in certain cases. But broadly, as I covered, there are, personal use, non-commercial use, use for research purposes and education purposes. Those are the four common heads where, which constitute fair use. So those are quite clear, but there are certain areas which are quite gray, and, it is for the courts to interpret. So it's better to avoid those areas, and mitigate risk by
Right.
using those.
In fact, I remember of one like case where an organization had come to us. So this organization, they work on women and girls, and on empowerment. And
Hmm.
like many years back, about 10, 15 years back,
Hmm.
they had created a bunch of songs. They had recorded songs, of various artists, that they had commissioned those songs, and the songs were now available like in a cassette form,
Hmm.
and it was not in any digital version. So they wanted to first of all like convert that into a digital files and then put that out. But they were unsure as to how to protect that, because their fear was that if they put it out, then others could use it without giving proper credits and so on. So in this case, is it important to kind of register like the contracts and all of that in place, uh, or the recording that makes you the actual owner?
Yeah, so I mean, as I said, it's not mandatory to register it as a copyright, but it helps to
Hmm.
enforce the rights. Like if there is a dispute, if they have to, kind of show that I am the owner and you got to pay me the royalties, then it helps. But for getting the royalties for the music work, you need to join the societies and the associations, and they help you enforce your rights. So
Hmm.
similar situation will apply in the example that you've given about the recording that he's going to, you know, um, kind of play on the YouTube, and he's kind of apprehensive that he may not get the payment that he should get.
Right. Wow, I am coming to the final sort of part of this podcast in terms of like about understanding what are the trends that you have seen, like as far as IP is concerned, like maybe like in India or outside, like are there any trends that you have seen that organizations in the social sector need to be aware about, like in the coming decade or so?
Yeah, the growing use of AI and digital tools to create content, technology, and and other products. It is presenting new challenges and opportunity as well as opportunities. AI generated works raise new questions about authorship and ownership, as I also discussed in another example. Therefore, not-for-profits that rely on digital content heavily, such as educational materials, data sets, or creative assets, they may need to adjust their IP policies to address the AI-generated works and software
Hmm.
developments. So it will be crucial to have, to ensure a clear ownership in those cases, that who has the right to use AI generated content. So that's going to be crucial in the trends that you were asking about. Then there are nonprofits are increasingly operating in a globalized environment, and therefore understanding international laws, IP laws, and protecting their assets across borders is also becoming important.
Hmm.
Every country has their own different IP laws. So nonprofits should also consider being aware of, the international laws and have global strategies in place for registering and enforcing their IP rights in other countries. Then another trending thing is blockchain technology. Use of blockchain is also prevalent now. I mean, for NPOs, I'm not sure, how much it depends, like,
Hmm.
scale of their operations, but they can look at blockchain as a tool for managing and protecting their IP, especially, the digital art, publication, and the creative content, which can be
Right.
protected, which is a more secure way of, protecting or tracking the ownership and ensuring that the, creators are duly compensated for their work.
Right.
Yeah.
Wow, thank you so much. I think we covered quite a bit of issues. you know like it was good that you kind of talked about different sort of IP mechanisms, whether it is trademarks and patents and copyrights, trade secrets, in donor databases and so on. Yeah, I think it was a fantastic discussion, and thank you so much for your time and for doing this. I'm sure organizations who are working, especially in the social sector, will find this useful in their work, and this is something that will make them, reflect and take a note that what are the things that they need to protect, what are the IPs that they already have, and something that they need to protect. Uh, so thank you so much, Rachna, on this.
Great, Simit. Thank you so much. It was a pleasure.